5 seconds. Tewatia J, as he then was, who delivered the minority opinion, also approved the interpretation placed by this court in Bhagwati Prasad case on the scope and effect of section 110B of the Act. There was thus complete unanimity among the three learned judges constituting the full bench in Rajpal Singh's case as to the impact of section 110B on the question whether the claims tribunal is competent to entertain a claim for compensation which is directed not only against the owner driver and the insurer of the vehicle but also third parties. The full bench of Punjab and Haryana High Court disapproved on the decisions of the Himachal Pradesh High Court in Bhola Ram versus State of Himachal Pradesh AIR 1982, Him Para 11, Madan Lal Jain versus Municipal Corporation of Delhi AIR 1982, Delhi 282, Swarn Lata versus NTI Private Limited AIR 1974, Guwahati 31, Oriental Fire and General Insurance Corporation versus Union of India AIR 1975, Andhra Pradesh 222 in so far as the purpose and scope of section 110B is concerned. The reasons why the full bench was not inclined to accept the construction put by these high courts of section 110B have already been quoted above. With respect, we entirely agree with the decision of the Punjab and Haryana High Court as to the effect of section 110B on the power of claims tribunal to entertain petitions for compensation which are directed against third parties in addition to the driver, owner and the insurer of the vehicle. It may be recalled that in the case before the Punjab High Court, the claim petition was directed solely against the railways and there was no allegation that the use of the motor vehicle had in any way contributed to the cause of the accident. It was for this reason that the majority held that the claim petition in question was not entertainable by the tribunal. In addition to the reasons which were given by this court in Bhagwati Prasad's case AIR 1982 Allahabad 310 and approved by us as well as those rendered by the full bench of Punjab and Haryana High Court AIR 1986 Punjab and Haryana 239 as well as the Gujarat High Court AIR 1988 Gujarat 13 Supra, we may also refer to section 110E of the Act, which also supports the view we are inclined to take, namely that the tribunal is not confined in its jurisdiction to entertain claim petitions against the driver, owner, and the insurer of the vehicle. The learned judge referring the questions was influenced by the three decisions Viz. Bhola Ram versus State AIR 1982 Himachal Pradesh 11 Oriented FIR and General Insurance Corporation versus Union of India AIR 1975 Andhra Pradesh 222 and Alimal versus Government of Tamil Nadu AIR 1987 Madras 80. The first two of these decisions have already been commented upon by the full bench of the Punjab and Haryana High Court, and as we are in agreement with the view expressed by that full bench, it is unnecessary to repeat the reasons which have persuaded us to hold that section 110B does not have the effect of widening down the scope of section 110 so as to be confined to the claims directed only against the driver, owner, and the insurer of the vehicle. As regards the decision of the Madras High Court cited above, with great respect, we do not agree with its interpretation of section 110B. We have already elaborated our reasons for taking the contrary view. Further, the construction which we are inclined to place on the effect of section 110B on the scope and jurisdiction of the claims tribunal under section 110(1) to entertain claim petitions against third parties as well as finds full support from the opinion expressed by the full bench of the Punjab and Haryana High Court. With respect, we prefer the opinion expressed by full bench of Punjab and Haryana High Court to the interpretation sought to be placed on section 110B by the Madras High Court.